very impressed with the creativity of the ads that we've heard, and they always seem to be right on point, even without us having to come up with what's going to be said.
I've been doing business with News Talk Radio for quite some time. It's the best place and the best value you can get for your advertising. They're very professional. I was actually blown away.
The commercial that they put together was awesome. It was way far above all the other radio stations.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
WSDT Sunny Daisy.
CBS News. I'm Steve Kathan. Republicans who vow to scrap Obamacare have met on Capitol Hill with Vice President-elect Pence to chart the course ahead. We're live with CBS's Stephen Portnoy.
And Democrats have been huddling with the president on a political strategy to pressure Republicans into not repealing his signature legislative achievement. They intend to stress the pain that repeal would cause for millions who've gotten Obamacare coverage. But after meeting with Vice President-elect Pence, who spoke of executive actions that Mr. Trump might take, House Speaker Paul Ryan pledged an orderly transition.
In that transition, we want to make sure we don't pull the rug out from anybody during that transition.
Democrats won't have the votes to stop the GOP if Republicans stick together. Steve?
Congressional correspondent Nancy Cordes tells us Democrats are vowing to do what they can to protect Obamacare.
Chuck Schumer, who is the new Democratic leader in the Senate, has a new catchphrase this morning, which is "Make America Sick Again." That's the Republican attempts to repeal Obamacare.
In a tweet, Trump said Democrats were careless, referring to the hacking upon the presidential campaign. The president-elect, who's cast doubt on Russia later on this week with intelligence officials. More than law school professors have written the Senate urging that lawmakers reject of Jeff Sessions to be Attorney General. Erwin Chemerinsky of the University of California, Irvine, is one of
Jeff Sessions enforcing civil rights laws is really unthinkable. The idea of Jeff Sessions who denies enforcing environmental laws is unthinkable.
Yesterday, the head of the NAACP, others were arrested. They staged a sit-in at Sessions in Alabama. Officials in Brooklyn, New York say more than 100 people were hurt. A commuter train hit a rail station bumping block. Many were staying off when it happened.
I was getting up from my seat, and there was a loud impact, and I flew backward. And then it was still...
Andrew Cuomo.
The most significant injury is a possible broken leg. That's a woman who's been transported to the hospital.
Jurors in Charleston, South Carolina are due to hear from witnesses in the death penalty phase of the Dylan Roof case today. The man convicted of the church massacre. Roof is now potentially could question attack survivors.
The judge Monday ordered Roof to stay as far away from his victims as possible, and you can bet that courtroom security will ensure that that takes place. The defendant, meanwhile, said last week that he doesn't plan to closely cross-examine any of the witnesses against him.
With CBS News senior legal analyst Andrew Cohn. Two private surveys out today say auto sales hit a record high last year, around 17.5 million. Wall Street right now, the Dow is up 27 points. NASDAQ is ahead 32. This is CBS News.
1 and a 2 and a 1 and a 2.
Oh, Jerry, I just can't. My muscles are so sore.
What you need is some soothing relief. When I get aches and pains, I just reach for the Tiger Balm.
Tiger Balm? Does that really work?
You bet it does. Tiger Balm's blend of essential oils is fast, proven pain relief. Tiger Balm works where it hurts.
Jerry Rice, after all these years, you still get sore?
You try dancing with a linebacker sometime.
Roar back from pain with Tiger Balm. It works where it hurts.
Getting a great night's sleep is easier and more affordable than you might think. You don't need a new expensive mattress or sleeping pills. You just need to change your sheets. Hi, I'm Scott Tannen, founder of Boll & Branch. What makes Boll & Branch sheets different is that they're meticulously crafted from pure 100% organic cotton. And because we only sell online, we've cut out all of the expensive retail markups. Plus, if you go to bollandbranch.com today, we'll give you $50 off your first set of sheets when you use promo code SOFT. bollandbranch.com, spelled B-O-L-L and branch.com. Promo code SOFT.
A ubiquitous TV advertiser is facing some pushback.
I'm Peter King. You've probably seen the ad hundreds of times.
Hello, I'm Mike Lindell, inventor of the world's most comfortable pillow, My Pillow.
But now the Better Business Bureau has given the company an F after consumer complaints said its continuous buy one, get one free offer is misleading and confusing, not a special offer as the ads indicate. The BBB says some consumers have said the pillows aren't exactly as seen on TV, even though the packaging says so, nor are all pillows identical to pictures of them on the boxes they come in. MyPillow CEO and owner Mike Lindell says the company is looking at changes, but wasn't specific. Peter King, CBS News.
Well, the lights went out around 7 p.m. last night at the Washington Monument, and when technicians got there this morning, they were back on again. Officials believe the automation clock for the lights is simply out of sync. Steve Kathan, CBS News.
Message and data rates may apply.
If you're considering going back to school, ask yourself the following questions.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240.
After this cool start, lots of sunshine and great looking weather again for your Monday. Still looking dry though for the next several days. Highs upper 70s. Tonight, clear, cool lows mid and upper 40s. For Tuesday and Wednesday, the warm, dry weather continues. High 75 to 77. For lunch or dinner, come to Guthrie's, home of the original golden fried delicious chicken finger with their special sauce. Open daily, locations in Trenton, Signal Mountain, Ringgold, and now 5203 Brainerd Road. That's Guthrie's. And I'm 1412 Chief Meteorologist Patrick Orr. On AM 1240, Hot News Talk Radio.
Martin Truex Jr. is off the pace and he is headed to the pit lane. Elliott powers around the outside. Michael McDowell pops a right front tire. Here's Martin Truex to the bottom. Blaney blocks him off too. Meanwhile, Chase Elliott went 4 wide on the back straightaway. They're side by side for the lead.
Hear it live on Chattanooga's official NASCAR radio station. Fox News Talk 1240. The voice of NASCAR.
All right, we're back to Hot News Talk Radio. This is Jim McComb with a weekly show, Legal Bytes. That's B-Y-T-E-S, Legal Bytes. And I can't believe that this is our first year of 2017. My gosh, where it's time gone. We'll do our show this year. I have with us today Trevor Ashley with the firm of McCoon, Williams, Ashley, and Stanley.
That's right, Jim. Thank you for having me.
I was welcome back. I hope you had a good holiday.
I did. Happy New Year to you.
Thank you very much. I know I'm amazed that this is our 5th show. Frankly, we've been trying to move this along. For those who have just now started listening, Legal Bytes. Byte is a small measure or segment of information, and that's what we try to do each Wednesday between 11 and 12 is give you, the listener, some quantum or measure of legal information that might apply in your life or something that you might can use. I guess over the past shows, we've talked about criminal issues. We've talked about the liability of a child and the liability you can have for your children under Tennessee law. We've talked about party liability. If you decide to host a party there at the holidays with New Year's, what responsibilities do you have as the host? And we've also talked about, kind of far-fetched, but we've talked about administrative proceedings and the standard of arbitrary and capricious that applies to the actions of administrative boards and how they affect the public. So today, coming out of the holidays, I've seen a lot of family. I don't know, did you spend a lot of time with your family, Trevor?
We did, yeah. Christmas and over New Year's, we had quite a bit of family time.
Now, you're a local boy, if I remember correctly.
That's correct. My parents live here, so we spent some time with them. We have 2 children, which of course are their grandchildren, whom they absolutely adore. And I think they prefer our grandchildren over us, quite frankly. And then my wife's father also lives in town, so we spent quite a bit of time with my family and with her family.
And I bet they're all of the grandparents are getting a little older.
They are getting a little bit older, yes.
That's something that I noticed when I was visiting with some of our family was the age and what's going on with them. And I know that a lot of people in the community, when they are around family, they suddenly start noticing that Aunt Myrtle might be walking around in the backyard talking to herself, or Mimi is sitting in the corner acting like the newspaper pictures are actually people that have come to see her, those kind of things. And you and I, we're both attorneys, and we can do proper estate planning. I think, if you're planning for your future, one of the most important things you probably want to do is have a durable power of attorney. Durable meaning that it survives your own disabilities and mental incompetencies. and you can have them springing or not. And springing basically just means to you, the listener, that it doesn't come into play until your disability arises or your incompetency arises. So then we've got someone based upon our power of attorney that we've appointed that can take care of our financial affairs, our business affairs, our property, any responsibilities we got, make sure our bills are paid, that we're at home with water and electricity and the like. But if you see someone in your family, Trevor, that isn't maybe fully competent, or at least you have some questions about it, what can we do under Tennessee law?
Well, that's a good question, Jim. The Tennessee law does provide for mechanisms to protect disabled individuals, and the legal term for that is called a conservatorship.
Okay. What is a conservatorship?
A conservatorship is a legal proceeding in which the court removes rights from a person, in whole or in part, invests those rights or duties in another person called the conservator. And that can be the right to make medical decisions or residential decisions, or the right to manage your own property. And the sort of threshold issue in a conservatorship case is whether the person for whom a conservatorship is sought, which we call the respondent or the ward, is what we call a person with a quote unquote person with a disability. And
how do you do that? I mean, how is a conservatorship started if you've got that kind of issue? Let's say I've got Aunt Mimi that I saw at Thanksgiving, and then I've seen at Christmas, and I've noticed that there is a real difference in her and that she's having some real problems. And there is no power of attorney out there that will allow someone to take care of her. What do we do?
Well, that can really put you in a difficult spot, because particularly if the individual that you're concerned about is very private and doesn't share a lot of confidential information with you, obviously determining whether or not the person has a disability, you first would consult with their physician. And you may not have authority to consult with that person's physician absent their authorization.
HIPAA, I think, stops physicians and medical practices from being able to talk to someone unless they've got authority.
It does. That's correct. So in that instance, what you would do is you would have to file a petition for the appointment of a conservator, and then ask the court to direct the respondent to go to the doctor to be examined for purposes of determining whether or not the doctor will opine that this person is in need of a conservator.
All right, you're making me real uncomfortable here, because I'm 60 and I can see me in a few years with somebody in my family saying, wait a minute, Jim's not getting along so well. So can they just take away my right to be independent and the like? What happens?
Absolutely not. Conservatorship proceedings are an adversarial proceeding, and the respondent, the person for whom a conservatorship is sought, has a number of rights. And that includes the right to attend any hearing, to participate in the proceedings, in fact, to have, if they want, to have an attorney ad litem appointed to represent their interests.
But at that point in time, assuming it's me, I may only have Social Security coming in, so I don't have the funds to go hire one of you big highfalutin lawyers. What does the court do?
So in almost every conservatorship case, the court appoints a local attorney to serve as what's called a guardian ad litem.
And what's their job?
The guardian ad litem serves as an impartial neutral to go out and investigate the content of the petition and to file a report with the court of the guardian ad litem's findings.
So that guardian ad litem is still not my lawyer.
Correct. The guardian ad litem is nobody's lawyer. It's an agent of the court.
Okay, well, do I get a lawyer? If I'm the person they're trying to put away and take care of, I know I'm being a little harsh. I know they really are doing this with love, but do I get a lawyer?
If you request one, you do, yes.
Okay, the court will appoint one for me.
Correct.
Okay, and I don't have to have the money to do it.
Well, that's well, the cost of the attorney ad litem would be taxed to the respondent, but the respondent has the right to counsel. So the attorney that serves may have to do that on a pro bono basis.
If I don't have assets.
Correct.
And pro bono means just for the good of the court, basically.
Correct.
Okay. All right. So we've filed this petition, and a guardian ad litem's been appointed by the court to investigate and report back to the court. I've had a lawyer appointed for me who's going to take care of me and do what I tell him I think. And then the petitioners, my family members who think that I need help, they've got a lawyer. Then what happens?
So the court will, as soon as the petition is filed, the court puts out an order setting a hearing and appointing the guardian ad litem.
Now, is that going to be 9 months down the road?
No, it has to be within a specific amount of time. I think within 120 days.
Okay, so I'm not going to be dangling out there for more than 4 months.
Correct. And what ends up happening is the guardian ad litem goes out and investigates, and he has to file his report within 3 days before the hearing. And that gives all parties the opportunity to review the report and prepare for the hearing.
Okay, so let's say that we get to the hearing and my doctor determines that I do have a disability. Maybe I just can't handle numbers and funds well, but that I've got all my physical faculties. I can cook my own meals. I can still take care of my home. Do I still get stripped of everything?
No, the court is required under our law to impose what is the least restrictive alternative. So in that case, the court would probably just remove the right to manage, the respondent's right to manage his property, invest the right to do that in the conservator.
Or maybe just my money.
Correct, just your money, right.
Okay.
Whether it's your checking account or if you have equities in the stock market or something, whatever your property you're managing. And then the respondent, which now would be a ward, would retain autonomy and individual control over those other rights that were not divested.
Okay. Can I ever get, if I'm appointed a conservator for me, and that conservator is going to take care of my money for me? For example, I've got accounts over at one of the local banks, and they're going to take care of that, make sure my Social Security comes in, and they're going to pay my bills for me. Can I ever get that right back?
Yes.
How do I do that?
Well, it would, again, require medical proof where the respondent would submit to an examination and have a doctor opine that the person's faculties have been restored and that they're no longer a person under a disability.
Okay, so if I was just having difficulties with the numbers because I was on a new prescription and it was making me foggy, if I get my prescription changed and I suddenly become lucid again, then I can petition back and get my autonomy and independence back that I want. I've had it all my life. The mere fact that I may be in my 70s or 80s doesn't mean that I still don't want to be independent.
That's correct.
Okay, so there are protections. The question I've got is, I know I've lived in neighborhoods where there's been an older person down the street that doesn't seem to have family involved. And I've seen those people start to go down, and I worry about them, but I feel like I don't really have any right to do anything to try to help them. Who can file? Can I file a petition for a conservator for maybe Miss Smith that lives 4 doors down?
Well, under Tennessee law, yes, you can. The requirements for standing and to initiate a conservatorship action are extraordinarily broad. Any person with knowledge of the facts necessitating the need for conservatorship may institute a proceeding. So it doesn't have to be a blood relative or, frankly, any relation. It can be someone just with knowledge of the person's circumstances, and that the person then knows that in this case, this individual in your neighborhood needs someone appointed to help manage their person or property.
Okay. What if there's a family member abusing the person that you're concerned about as far as their competency or disability? Would a conservatorship be the way to protect them?
Most likely so, yes.
I mean, for example, let's say that we've got an older member in the family that lives in another town. We've all moved away, and there's a nephew or a niece that's moved in with them that's taking their money from them, that may be selling their prescription medications on the market, or using their money to buy inappropriate drugs and the like. Can we take the conservatorship mode to try to protect that family member and maybe get that younger nephew or niece out of their home?
Yes. So
how does that happen?
Okay. It's a sort of multi-step process. As I was explaining earlier, the law presumes all adults are competent. So as long as the person who's being abused.
Would you say that again for my wife? I am presumed to be competent.
Correct. Doesn't mean you exercise good judgment all the time, but you presume competent. Yes. And Until the court intervenes, the person whose assets are being taken or medications are being misappropriated or used has the right. Unfortunately, the law will allow that to happen until someone intervenes and gets judicial oversight over that. So the initial hearing on a conservatorship case is always just to determine whether or not the person is a person with a disability. And if the question of that is in the affirmative, then is the appointment of a conservator the least restrictive alternative? If so, yes. Then who is the proper person to serve as a conservator? Once the conservator is in place, then he or she can undertake actions to remove that person from the premises and or find alternative living arrangements for the person whose resources were being misappropriated, and with the court's permission can undertake legal action to restore the person and to go out and try to get their property back.
Okay. Now, what if there are family members that don't think that Aunt Myrtle and that's just being aged and that she's not infirmed, but she's just old, and that I'm being too aggressive in filing the petition for the conservatorship? Do they have any rights?
The closest relatives of the respondent are necessary parties to the action. And
so how far is that? What are closest relatives? How is that defined?
Well, it's next of kin. So that would be first, if you're married, your spouse.
Okay.
And then if you have living children, they would be included. When you start getting to more remote relatives, you're talking about siblings and parents. So what we're talking about, a person who's advanced in age, normally their parents are
maybe she's widowed. Perhaps she had 4 children, but 3 of them have already passed over time. And so now she's really just got nieces and nephews and 1 child left. So all of them would be noticed?
Under that circumstance, probably just the child.
Okay.
The more remote relatives, the nieces and nephews, are not required to notify.
Okay.
There's a caveat to that.
What is the caveat?
The other person entitled to notice is...
You mean an exception?
An exception, yes,
okay.
An exception.
Using those big lawyer words.
You're required to notify the facility where the person lives, or anyone who lives with the person or is in charge of taking care of them.
Okay, so if Aunt Myrtle's living alone, nobody else gets notified but that one living child.
Correct.
Under these facts.
Correct.
Okay. But if she might be at Pine Manor, some assisted living home or nursing home, the nursing home would be given notice.
Correct.
Why would the nursing home get notice?
Well, that's what the law provides.
But what is their rights in these proceedings?
Just to participate. They are only notified of the proceedings, and then if they want to come in and offer any evidence of whether or not this person is disabled, they would have the right to participate in the hearing.
Okay. All right. All right. So let's say that the conservatorship is granted and that you are appointed as my conservator. What are your responsibilities to the court and to me as you're holding all my monies and taking care of it? If I want $20 to go buy presents for my grandkids, are you required to give me $20?
No. That can be a lot of friction in conservatorship cases, particularly if on the use and management of the ward's property. The conservator's utmost responsibility is to act in the best interests of the ward. That is always to make decisions on the best interest of the person whose property he's managing.
Okay.
And that sometimes can be some conflict on what family members may think is in the ward's best interest and what an objective analysis says is in the best interest. And there also can be conflict between what the ward thinks is in his best interest and what an objective analysis would show was in his best interest.
So if you won't give me $20 so I can buy my grandchildren a birthday present, can I get that lawyer that was appointed to me to go back to court and say you're a mean so-and-so and are stingy with my money?
At that point, the attorney ad litem's job would have been completed. So
no, I'm talking about, you said the judge would appoint an attorney for me to be my lawyer.
That's at the initial stages where we're determining whether or not the person is a person with a disability, and at the initial hearing to determine whether if there needs to be a conservator, and if so, who the proper person is to serve.
Okay, so what do I do about getting $20 from my grandchildren?
Well, obviously, the requesting it from the conservator first would be the step. If that doesn't bear fruit, then writing a letter to the court, which the court will take as a motion, and we'll set it for hearing. And then the person can go and have a hearing and have their say to the chancellor and say, Your Honor, I don't think my conservator is managing my property correctly or within my wishes. I want to use $20 as a gift to my grandchild, and he or she is not allowing it.
Well, as mean as you are, how do I buy an envelope and a stamp to even send something to the chancellor? Because you sounds like you're a tough cookie.
Well, that's an interesting question. The conservator would have a duty to, I think, to assist the ward in having an opportunity to be heard on some of those questions.
Okay. So you better take care of me.
Well,
all right. So how long does the conservatorship last? If I don't get better, how long does it last? Is it limited in time?
No. Now an emergency conservatorship is, yes. An emergency conservatorship.
I don't know what that is. What is an emergency conservatorship?
So, the process we were describing earlier, where you file the petition and the court puts down an order setting the hearing and appoint a guardian ad litem, that all takes time. Okay. And if the person for whom a conservatorship is sought is in some sort of imminent peril, where there's a risk of substantial harm that the respondent may be injured, the court can appoint what's called an emergency conservator to come in and have authority to make decisions on behalf of the respondent. An emergency conservatorship is limited in duration, I believe, to 60 days. And emergency conservator can be appointed without notice to the respondent. But if that occurs, the respondent has to be notified in 48 hours, and you have to have a hearing within 5 days from the appointment of the emergency conservator. Then the respondent gets an opportunity to be heard in front of the court and can tell the chancellor, I don't need this, or family members can come in and say, we don't think this is appropriate. But you have a hearing on that issue on the appropriateness of the appointment of emergency conservator. If the emergency conservator remains in place, he can only do so for 60 days.
Okay.
And the statute expressly provides that those time periods are mandatory, not directory.
Now in Chattanooga, do we have one particular court that hears all these conservatorship issues?
That's correct. Part 1 of Chancery Court hears, assuming, unless there's a conflict with the chancellor for some reason, yes, Part 1 Chancery Court.
Now, that'd be Chancellor Fleener.
Correct.
Okay. And so are you before her on these matters on a very regular basis?
We are, yes, in different capacities. Sometimes as representing the petitioner, sometimes as a guardian ad litem, sometimes as a court-appointed attorney ad litem. So your conservatorships are multifaceted depending upon what role you're serving.
And do any of the assisted living facilities or nursing homes ever file petitions for conservatorships?
That occurs quite frequently.
And why is that?
Particularly from a nursing home where someone presents and is indigent and needs to have to qualify for TennCare or Medicaid. And the nursing home is without knowledge of the person's finances, and there's no one authorized to act on that person's behalf. The nursing home petitions the court for appointment of a conservator who can go out and investigate the financial holdings and assist the nursing home with qualifying that individual for TennCare so they can have a payment source for nursing home care.
Or let's say Aunt Myrtle went into Pine Manor and she was completely competent when she went in as an assisted living facility, but during the course of her stay, she becomes dependent or incompetent in some respects. Would the nursing home then have an authority and take action?
They could if they wanted to. Yes, they would have standing to do that because they would have the requisite knowledge that the person needs a conservator.
Okay. Now, if Aunt Myrtle dies while the conservatorship is going on, what happens?
So a conservator is a fiduciary, meaning he has authority to act on behalf of someone else.
Okay, so they're a trusted person.
They're a trusted person, and if
even though you didn't give me that $20 for my grandchild,
that's correct. So if the person managing the ward's property, his authority, just like that of an agent, ceases on the death of his ward, with an exception that the conservator has authority to make funeral arrangements for the ward and to pay reasonable funeral expenses. He'll get a credit for that on his final accounting.
Okay, so accountings, we'll have to talk about that on the next side. I understand we're just about out of time. if somebody wanted to reach you and talk to you about one of their family members, what's your email address?
It's tashley@mwalawfirm.com.
And how do you spell Ashley?
ATCHLEY.
And if they want to reach you by phone,
it's 423-756-6400.
All right. Thank you. This is Jim McComb. We are at Legal Bytes, and we'll see you soon.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240. McCune, Williams & Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal: providing the highest quality legal services to our clients through the combination of our talents, experience, and expertise. In each case, we strive to tailor those services to meet each client's specific circumstances. Business law, business organization, civil litigation, commercial litigation, conservatorship and guardian law, bankruptcy law, just to name a few. With over 188 years of combined experience, McCune Williams Ashley PLLC is here to help you and your business succeed. MWALawfirm.com. That's MWALawfirm.com. Call 423-756-6400. That's 423-756-6400.
Is your career careening, maybe sagging, wheezing? Let me suggest a job with huge income potential. Dealing with people. Call Steve Rajeda for a confidential interview. 855-8484. 855-8484. Maybe the most important call you make all year.
Are you shovel ready to build a house, but you're not a builder? Are you shovel ready? Michael's Homes is ready to bulldoze its way to a solution for you. You have ideas on what you want in a house, but you're looking for someone to bring your ideas into a plan and turn your plan into a house. Michael's Homes, custom builder. Michael's Homes has lots available at a new subdivision, River Bay Estates, that's Harrison. Maybe River Watch in Saudi Daisy. Choices galore, lots, houses, beautiful homes all over Chattanooga. The Canyons, Hickson, Crystal Brook, Appleton. Drive in, take a look, consult with us. We build on your lot or ours. Homes-Chattanooga.com.
Call 423-413-9929. There's a reason why Alliance Physical Therapy is a choice of professionals and those who care about first-class, top-notch service and treatment. Because at Alliance Physical Therapy of Chattanooga, we don't just treat the symptoms in your body. Whether you're suffering from stiffness, muscle spasms, back pain, chronic headaches every day, stress of life demanding more and more of you, Alliance Physical Therapy takes a holistic approach to healing, mind, body, and soul. Alliance Physical Therapy with a location near you and 9 others in the Chattanooga area. If you don't have a doctor or if your physician's plan for chronic pain is not working, Alliance Physical Therapy will help. Visit Alliance Physical Therapy on the web at nopainpt.com. That's nopainpt.com. Alliance Physical Therapy. How about we change that to Built in the USA? For over 21 years, Affordable Computers has been building computers right here in the good old USA, in Chattanooga, using the highest quality parts and components in every new computer they build. Tell us the exact system you need, we'll build it to your specifications. Or you can choose from a wide selection of our PCs and laptops, starting at under $200. All Affordable Computers are upgradable, guaranteed. Affordable Computers services their computers in store, typically within 1 to 3 days. And when you call, they answer the phone. You get support within minutes that you can understand. Affordable Computers of Chattanooga. And service and support extends for the life of the computer, not just for the warranty of the PC. So there's no reason to shop anywhere else. Call Affordable Computers now on Highway 58 Chattanooga, 423-499-1975. That's 423-499-1975.
Or visit our Fort O store, 706-858-5888.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240. AM 1240 Nooga Radio News. Russell Stroud reporting.
If you don't have insurance, beware. The city has found a new way to make you pay. License plate readers are going to be placed at fixed locations in what Police Chief Fletcher called ingress and egress points in high crime areas. These license plate readers can, of course, read your license plate and tell if you don't have insurance or not. Fred Fletcher claims the purpose is to catch the bad guys. Carol Burrs had safety concerns, but he waved them off, saying, "You're on camera anytime you enter a building in Chattanooga." With the March elections for city council and mayor raging closer and closer, the Election Commission has decided to put up 3 new early voting sites, which is a number down from the original 5, which was requested by Councilman Chris Anderson. Early voting starts February the 15th for the city mayor and city council races. The election proper is in March. Highland Park is going to be getting a new fire hall and a new soccer field to the tune of $1.5 million, a little over that. If it's going on the Tennessee Valley, it's going on Nooga Radio News.
Expect breezy and cooler weather out there through your afternoon. A little sunshine will try to return, though. Highs staying into the 40s tonight. Lows upper 20s to near 30. For Thursday, partly sunny. Highs back into the upper 40s. Colder tomorrow night. May see a late flurry with some patchy light snow possible Friday morning. Looking for your dream home? McBride Realty can help. With decades of experience, they get big-time results with small-town values. Licensed for the tri-state area. Check McBrideRealty.com for their complete listings. And I'm Swarsheen 12 Chief Meteorologist Patrick Orr.
On AM 1240, Hot News Talk Radio.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240.
Welcome back to Legal Bytes. This is Jim McCoon. I'm here with Trevor Ashley, and we're here today talking about basically conservatorships and fiduciary arrangements and ways to take care of those who may be infirmed, either by age, being elderly, or by age being too young to take care of themselves. Boy, I love that theme music. Perry Mason, again, I'm older, so Perry Mason was like the first TV lawyer that you ever saw, and it was Perry Mason and his legal assistant Della Street, and then he had Paul Drake as his investigator, and I don't think he did anything but criminal work, but he had the whole office in there. When he went to the courtroom, all 3 of them were there. I mean, they had to just shut the place
down.
And I will tell you, the listener, as attorneys, we cannot praise enough our assistants, the investigators, the process servers, the various people that help us do what we do for you. They're just invaluable. Now, Trevor, as I understand it from your practice, you primarily have an emphasis in fiduciary law.
That's correct.
Okay, so you do conservatorships.
Correct.
In various aspects. You said you do guardian, you're the guardian ad litem sometimes you're petitioner's counsel, sometimes you're respondent's counsel.
Correct.
Okay. What other things would you consider as fiduciary law?
Well, I guess the most fundamental would be just a regular agency arrangement where someone is authorized to act under a durable power of attorney, whether a financial or healthcare.
So you take those roles too.
And advise clients on whom they want to authorize to act on their behalf.
And then if that person holds a power of attorney, what they should do to help the person that they've got that authority from.
Correct.
Okay. And do you trust themselves? So you get involved in representing trustees?
Yes. And on some of the same factors, again, advising the settlor on who the proper person is to serve as a trustee, advising the trustee on his or her responsibilities and duties. There's under Tennessee law, there's other fiduciaries, a trust protector or a trust advisor, and advising those fiduciaries on what their roles and duties are.
When you're talking about a self-service trust, if you're setting up a trust yourself for yourself, you can do that.
Correct.
And that's a wonderful topic for another show. But I want to get back to what I was asking you before. You mentioned accounting and that the conservator can get some type of credit for what he spent on the funeral, on his accounting. And I'm not sure we've heard that term. What is an accounting and when is it required by the conservator?
I think it's a phone call.
Oh, we have a phone call. Jim McCoon, Legal Bytes. How can I help you?
Yeah, I'm watching you on YouTube. One of you looks like they're ready for court. The other one looks like you're ready to go golfing.
It's a wonderful week of the holidays right afterwards. Yes.
But it looks like the one for golf is going to have more fun in court for some reason. Okay, here's what burns my butt. There was just a report on the radio that our illustrious chief of police is going to allow these readers to catch people without insurance. Ooh, the big criminals passing laws, to help the insurance industry. You have to have insurance. Ooh. Yeah, what is it that we are being invasive? Where's the probable cause? Where's the reasonable suspicion? Can government just sniff everyone's underwear and just with no probable cause read your license plate and find everything about you? I find that so repugnant that they should send this guy back to Texas. They should drag him behind horses back to Texas. My other question is HR 4919, which is talking about chipping Alzheimer's patients and some children that fit that particular category. And the House passed it December 8th. So now we're talking about chipping people. I want to know what we can do if we need to hire attorneys, or your legal position on turning Americans into cattle or chattel of the government, and also allowing people like this lunatic.
We've lost you, caller. Okay. Let's try to deal with what we got. I think we lost the caller on that call. So let's talk about first the law that's right now pending, or the bill that's currently pending up in Nashville with respect to the possibility of as he put shipping. Are you familiar with what's going on?
I'm not familiar with that. It sounds like he was saying chipping, like they would put some sort of locator in a person.
Okay.
And I mean that to me, just at the offset, seems without the person's consent to be unconstitutional, an invasion of their personal liberty. The concern, I would presume, is that when people are advanced in age and have dementia, whether it's a vascular dementia or Alzheimer's disease or something, some of them do elope, and so you are worried about having them somewhere where they're safe.
That's a very romantic term for when your mother's out 4 miles from the house wandering. Right. She's eloping.
She's eloped. Yes.
I like that.
But it seems to me that, again, with conservatorships, and the law provides we always need to impose the least restrictive alternative. Imposing a chip does not seem to fit in with that objective of our law.
I agree with that. And then with respect to the requirement of uninsured motorist coverage and the compliance stops, again, there's a difference between a random stop where you do have to have some articulable suspicion based upon either the car is weaving light, that's the old Terry versus Ohio standard, versus a traffic stop where you've got a stop announced and it's for compliance with laws. And as a father and husband of a family that was hit by an uninsured woman a few years ago, I will tell you, I am not the host to be calling on that issue, talking about the rights to drive uninsured, because I think it is absolutely, if you're going to have a right to drive on the roads of Tennessee and have a license issued by the state of Tennessee giving you authority to use that vehicle, then you need to comply with all laws, including financial responsibility. And frankly, I'm not sure $25,000 is enough. But let's get back to the topic we were discussing earlier, and that was the accounting. What kind of financial accounting is there through the courts? If you've got my money and you're controlling my assets, what can I expect that the court's going to make you do?
Okay, so right at the offset, the court requires what's called an inventory. And that is where the conservator goes out, takes control of the assets of his ward, and inventories them for the court. And that's the value, listing them, identifying them, and listing their value on the date of his appointment. With that, he also files what's called a property management plan, where he tells the court, this is how I plan to use the ward's property in her best interest or his best interest for his maintenance and care. At the 6-month date following his initial appointment, 30 days from that date, the conservator is required to file an accounting that shows, it has to be itemized and supported by original copies of bank statements showing how he used the funds. And that gets sent out to anyone entitled to notice of the proceedings. And you were mentioning earlier how grateful we are for our staff and support staff. The clerk's office in the Hamilton County Guardianship Division does a great job of reviewing the accountings. And if there are no objections made and the accountings look good to the clerks, then it's sent to the chancellor to be approved.
Okay. And how often will these accountings go after that? Let's say, I live for 5 more years. How long will those those accountings occur?
Annually after. So the initial accountings due 6 months following, 30 days after the 6-month date following appointment, and then annually thereafter. So every year. Now, after the person passes, assuming that the ward died, the conservator would again be able to use some funds to pay for the funeral. He'd get a credit on his final accounting for that. But then whatever funds are remaining, he has to tell the court, here's what I have, what should be done with the funds.
Okay. Now, Trevor, there may be people out there that are addressing some of these kind of issues in their families and would want to ask you a question. Are you available for a call while we're here today?
Certainly.
Okay. You can call us at 423-800-8949. That's 423-800-8949 if you need to speak with Trevor about any issues in your family. Now, there's another area I've heard about called guardianships. Now, do you have to decide for somebody if you're going to get a guardianship or conservatorship?
Not in Tennessee.
Okay. What's the difference in a guardianship and a conservatorship?
In Tennessee, a conservatorship pertains only to adults, those individuals who are over the age of 18.
Okay.
A guardianship is a court-appointed fiduciary appointed over a minor child.
Okay. So when would you want a guardianship for a minor as opposed to just having a parent serve for that minor?
So there's a couple of different scenarios there. And this type of guardianship proceeding is different than what you might have heard about in juvenile court, where a child's been adjudicated dependent and neglected. This type of guardianship case is typically where either the parents are deceased or the child has become entitled to money in excess of $20,000.
Let's say that there was a major car wreck and a tractor trailer has hit my clients, and my clients include a mother and father, and then there were 2 children in the back, and everyone survived, but there's some really serious injuries. And so we go to court, we end up settling the case. The settlement is allocated per each individual in the car, and these children are going to receive, let's say, $100,000 each as a result of what happened. Can I just take that money in and give it to the parents to hold for the children?
No.
All right. What has to be done?
That's a circumstance where the appointment of there are a couple of different scenarios, but the most likely is you would ask the court to appoint a guardian, and it could be that the child's natural parents serve as the court-appointed guardian.
Well, I had some legal problems in the past, and I've served in a couple of jails. So can I still be my children's guardian?
If you've had a felony conviction and served time in the penitentiary, Tennessee law generally prohibits you from serving as a court-appointed fiduciary.
Okay. Do I have to pay somebody to be a guardian?
A court-appointed guardian typically will charge a fee, yes.
Okay. What, can I just get another family member?
Another family member can serve. Ultimately, however, it's up to the court. The court has discretion on who to appoint to serve as a guardian. Now, Tennessee law provides a hierarchy of persons the court should consider first, a priority.
Okay.
First in line, as you might imagine, is the child's parents. They're
Okay.
they're the natural legal guardians. If for some reason the parent's not fit, then you go down in order. For example, if the parents are deceased, you would look for any writing where the parent has nominated someone to serve as guardian.
Would prior bankruptcies exclude me from being my child's guardian?
Not per se. No,
Okay.
It's not a per se prohibition,
Okay.
but that would be a factor the court would consider in whether or not you should be a person to serve.
May indicate that I don't handle funds well.
Correct.
Okay.
And again, with the guardianship, you have the same accounting requirements as you will with the conservatorship. So the court's going to be aware of how you're managing the minor's funds, and if there was any self-dealing that you couldn't. In other words, if there were transactions where you couldn't account for the use of the funds, the court then would probably remove that person and appoint someone else.
I can't take those monies and go to Cabo or something.
Correct.
Okay. Now, let me ask you, let's assume that I'm appointed as a guardian. Can I go and run over to Merrill Lynch and say, I want to get into speculative stocks because I think we're going to make a whole lot of money off these funds?
Probably not. No, that would be up to the court to approve the investment plan.
All right. So I've got to actually have a plan when I go in.
That goes to the property management plan, correct, where you would ask the court to approve investment in, mutual funds. If you're talking about, speculative type of investments, I don't think that's a prudent investment. The court probably would not approve it.
Okay. What is the court's interest in the guardianship when we're trying to talk about these funds?
Well, again, protecting the best interest of the child and ensuring those funds are maintained for his or her benefit. You asked me earlier about bankruptcy and whether or not that was a per se prohibition. It is not. A lot of times, though, when you manage someone else's property, the court requires you to post a bond, a surety bond, where making sure if you don't use the person's property correctly, there's an insurance policy in place essentially to reimburse the person whose property you're supposed to be managing.
Now, I heard something though that you can have what's called a no withdrawal account.
That's correct.
And what is that?
That is an agreement that's approved by the court between the court-appointed fiduciary and a financial institution.
Court-appointed, talking about the guardian.
The guardian, correct. Yeah. I'm sorry.
Don't talk big law.
The guardian, correct. Yes, where there's an agreement between the guardian and the financial institution.
So, say I sat down with the bank I use, and they have a investment department.
Correct.
Okay.
And they would enter into an agreement where they would hold the money and agree not to allow any withdrawals without a court order specifying, yes, you can withdraw this money. And that is a adequate surety for the court where then you don't have to have a surety bond in place.
Okay. And who's going to be paying the lawyers to do these orders every time money's got to be pulled?
Well, that comes out of the funds that are held for the benefit of the child in the case of a guardianship, or for the benefit of the adult in the case of conservatorship.
So I don't have to be worried whether I'm appointed a conservator for my grandmother, or as a guardian for my child, or for my niece or nephew if my brother was killed with his wife or whatever. I don't have to be concerned that I'm going to be out of pocket for the lawyers doing these things.
Generally speaking, yes, that's correct.
Okay, it's going to get paid for out of the funds that are being held or managed.
Assuming you've done everything correctly, yes. Now, if you've committed some malfeasance and self-dealt and can't account for the money.
As long as I follow the rules,
correct.
I don't have any responsibility.
Right.
Okay.
And attorney's fees, it's not carte blanche. You don't just get to pay attorneys whatever they say they're owed. That all has to be court approved.
Okay. And how does that happen? What if I think you're just doing a terrible job and you want to get paid? Do I get notice that you're asking to be paid?
Absolutely, yes.
And will the court hear me if I go up there when you have your hearing on being paid?
Yes. You'll get to explain to the court why you think the fee is unreasonable, and then the court will look at it. Has to be supported by an itemized statement. The court reviews the itemized statement and lists any concerns that the parents have, or a relative has, or anyone else who's involved in the proceedings has, and then ultimately we'll decide what's a reasonable fee for the services that were rendered.
Okay. Now, if I have questions and don't want to bother you and run up your legal fees on my ward's funds, will the clerk's office talk to me?
They can provide you general advice about filings that have to be done, but they cannot provide legal advice.
Okay, so I can't go up there as a guardian and say I need to know X, Y, and Z.
Now, that's correct. I will tell you that the clerk's office does a really good job of informing the guardians and conservators of their duties and responsibilities. They have a packet you get when you're appointed to serve, and it sort of gives you a checklist of things you have to do. However, the preparation and actually getting those things, for example, an accounting itemized and supported by all the adequate bank statements, often requires a degree of sophistication that an average person might not be able to do.
Okay.
So it's important to have competent legal advice to assist in the preparation of those things, and also to know what you're allowed to do and not to do. Because if you get into a situation where sometimes parents will think, well, my child's entitled to this money from this settlement. I'm going to use some of it to pay for this special education that is available. And that may be an appropriate expenditure, but you either have to get the court to approve it before you make the expenditure or after you make the expenditure. The risk being, if you ask the court to approve it retrospectively afterwards, and the court says, oh, this is not an appropriate expenditure, then the person who spent the money may be personally liable for that expenditure.
So if I decided to enroll my child into one of the private schools and signed the contract and then went to the court and said, look what I've done, the court may not think that's appropriate.
Correct.
Especially, and you also have to look at the proration of how much money that tuition is compared to how much total money I'm managing.
Absolutely, yes. And how much income it's earning and all those things. Correct.
And what public alternatives that child already had, maybe.
Correct. Right.
Okay. So how about computers? Will the court authorize me to buy a computer for my child that they need for their homework?
Can, absolutely, yes. The court's always going to be focused on what's in the child's best interest. And again, it's something that you would need to go up and ask permission for before you went out and expended the money. But yes, the court absolutely can approve that.
What if a child is say tragically brain injured, and so then I assume because it's a child you'd appoint a guardian, but at some point in time that child becomes 21, 24, 28, 30 years old, they're still brain injured. Does that guardianship convert to conservatorship?
Not automatically. You'd have to file a separate petition when the child reaches the age of majority to ask the court to appoint a conservator.
Will the guardianship just go away at age 18?
No, it can be extended, but that's not indefinitely. We have to look at the statute. They made some changes. I think that it can be extended to age 22.
Okay, so if nobody extends it and nobody does anything, then that injured child that's now become an adult will then suddenly be free of any of the shackles or the protections of the guardianship.
That's correct, because the guardianship, the only reason you need a guardianship is because of the legal incapacity of infancy. That is, the person for whom you're making decisions or managing their property is not 18 years old or not legally competent to manage their own property.
This has really been fascinating to hear what you do and how you do it. Again, if anybody out there that's listening and wants to reach you, what phone number should they call you at?
423-756-6400.
And that's for Trevor, actually.
Correct.
Okay. And as far as your email, if they want to just contact you directly by email?
It's tashley@mwalawfirm.com.
Okay. Thank you so much for being with us today, Trevor. And you out there, we will talk to you again in approximately a week. This is Legal Bytes, Jim McComb with McComb, Williams, Ashley, and Stanley. Talk to you later.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240. McComb, Williams, and Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal: